Good morning, everyone. I'm Leslie Spencer with AARP Florida. Thank you for joining us for our latest edition of Coffee, Caregivers, and Conversation. As many of you who have joined us previously can see, this is a new platform for us. So we are streaming live right now on Facebook and YouTube, and we're really pleased that you're with us today. As we learn this, please understand we may look in the wrong place or mute ourselves or do something silly, but it's all part of learning. So thank you for your patience in being with us today. I am really excited to have Ryan Singleton with us today from Singleton Legal. Ryan is a board certified bankruptcy attorney, and he also works with individuals and families and couples who are dealing with financial issues. So I'm really excited to have him with us today and share his expertise. Before I turn it over to Ryan, I wanted to make folks aware that if you have a question or a comment and you're in Facebook, please put it in the comments section. We'll be able to see that live. Same thing for if you're on YouTube, put it in the comments section, and we will take questions and comments at the end of the webinar. Don't worry if you are not able to get your question answered. Ryan will share his contact information and will also be sharing his slides and information to everyone who participated today. So without further ado, welcome, Ryan. Thank you so much for being with us.
Thank you very much for the introduction, Leslie. It's a great pleasure to be online with all of you here today. Before we begin, I'd just like to mention that in addition to the comments features that Leslie mentioned, I will also provide my contact information at the end of this presentation. So if you do have any questions or concerns that we're not able to address today, you can feel free to contact me directly. All right, so we're going to start by getting a slideshow ready here. Let me pull that up. Okay, so we should have this, yes, our slideshow going. That's just who I am and what we're doing today. And then we have some legal disclosures there. All right, so today we're going to talk about finances, which I know can be a stressful topic. While there's no magic way to make it easier, my goal is to light your path a bit by providing some helpful information and pointing out some of the resources that are currently available. We'll start by looking at some specific financial considerations for caregivers, and then we'll talk about the financial relief made available from the COVID-19 legislation, and then finish up by discussing what to do when you're in default. So let's jump right into it here. We know that the majority of caregivers are either managing their loved one's finances or are financially supporting their loved ones themselves. So let's talk about what you need to do it. First and foremost, power of attorney. This is a necessary tool for any caregiver to help their loved one with their finances, as it provides the authority to act for another person, legal or financial matters. This must be set up while a person still has the capacity to authorize it. So it's important that this is set up early before any potential significant mental decline occurs. Once established, you may want to have duplicate financial statements and records be sent to you, the POA, for purposes of monitoring account activity. Paying bills. That can be a cumbersome process. It's especially more difficult for the sick or elderly. Automating bill payments with direct debits from a person's checking account will help your loved ones stay organized while also minimizing the opportunity to get drawn into financial scams. Similarly, establishing automatic transfers of income into a checking account helps further organize financial affairs. It's far easier to have income deposited electronically as opposed to having multiple checks arrive through the month, and helps avoid losing or misplacing checks. For your non-automated expenses, it is advisable to use credit cards. Once cash or payment from a checking account is sent to another party, it can be difficult to get the money back. Making use of credit cards for most expenses protects against identity theft, giving you an opportunity to review and dispute any suspect charges. Liability for medical bills. Please know that you are not automatically liable for another person's medical bills simply through being that person's spouse, partner, or caregiver. This only happens if you sign something that says you're going to be liable. So You want to make sure you read any paperwork that you sign thoroughly. Do not sign any form which indicates you are personally guaranteeing payment. You want to watch out specifically for facility drafted healthcare surrogate forms. We've heard stories that facilities providing such forms that place financial responsibility on the surrogate if the patient does not pay, which just isn't right. As a caregiver, it can be helpful to consult with an estate planner, elder law attorney, or special needs attorney at the beginning of the process to help you plan finances. First, they can help you with those necessary forms like wills, POAs, and healthcare surrogates. They can also assist in applying for maximizing benefits that your loved one may be eligible for, or they can establish a plan to retain assets, income, or inheritances through revocable, irrevocable, or special needs trusts. Okay, so now we are going to get into the COVID-19 legislation that's occurred. Quick overview. The main source of the relief that we're going to discuss today came in the form of the CARES Act, the Coronavirus Aid, Relief, and Economic Securities Act that was signed into law on March 27th of this year. After that came the Paycheck Protection Program. This is for business loans. The House has passed the HEROES Act, the Health and Economic Recovery Omnibus Emergency Solutions Act, but the Senate has not moved on it. It does provide for some significant other relief, but until it happens, we'll just have to wait and see. So some of the general benefits, protections that have become available through the CARES Act. First, there was the $1,200 per person stimulus checks. Those have come and gone. The HEROES Act does have a provision for another round of checks in it, but again, we're just going to have to wait and see on that. Unemployment benefits, an extra $600 per week funded by the federal government, is available on top of state benefits, but this will run out on July 31st. Over 40 million people have applied for these benefits since the crisis began. Evictions, the CARES Act placed a moratorium on evictions through July 25th, but it only applies to certain properties that meet certain criteria. States that have enacted their own moratoriums, but nearly half of those have expired. Florida recently extended its moratorium on evictions and foreclosures to July 1st, which universally applies to all cases. Meanwhile, FHA, USDA, VA, Fannie Mae, and Freddie Mac extended their own self-imposed foreclosure moratorium to June 30th. One of the other benefits on the CARE Act is the Mortgage Payment Forbearance Program, which allows borrowers to temporarily pause or reduce payments on federally backed mortgages. The right to request a mortgage payment forbearance expires on December 31st of this year. Through this program, you can suspend payments for up to 180 days initially, and then you may request one additional extension for up to another 180 days, so you can miss payments for up to a year. While this program is only for federally backed mortgages, many servicers appear to be participating by granting initial 90-day forbearances. But what happens after the mortgage payment forbearance? The reality is that you will still owe your mortgage servicer for the missed payments. The CARES Act did provide for the COVID-19 Standalone partial claim to address this. It's a no-interest junior loan secured by your property. The proceeds go towards your mortgage servicer to make them whole for the payments that you missed. And so this loan remains on your property, but no payments are due on it until the payoff, maturity, or acceleration of your insured mortgage, including the sale or refinancing of the property, or the termination of FHA insurance on your mortgage. To be eligible for the standalone partial claim, you must have been current or less than 30 days past due as of March 1st of this year. You must have the ability to resume payments at the end of the forbearance period, and the property must be owner occupied. So what happens if you are not eligible for this standalone partial claim? At that point in time, your servicer will evaluate you for other home retention options, quote, pursuant to existing loss mitigation evaluation hierarchy, end quote. What that basically means for most people is that you'll be considered for loan modification, which is a common process that mortgages have been doing over the past decade or so to help people address their past due amounts and modify it into a new payment going forward. Other loss mitigation options include repayment. Some servicers will offer different types of repayment options, for example, making double payments for a period of time until you get current. And then the final type of loss mitigation options would be sale of the house, short sale, or deed in lieu of foreclosure. If you have the ability, you can always make a lump sum payment, and that's fine, of course. But to the extent that none of these options are available to somebody, and now you're a year past due on your mortgage payments, you will always have the opportunity to cure your arrearage through a Chapter 13 bankruptcy. But the sooner you choose this option, the easier it is to afford, because under the Chapter 13, you have to catch up on all the past due payments, interest, and fees over a 5-year period. If you wait until the mortgage company files a foreclosure, then that arrearage will include attorney's fees, which can get expensive. There were some bankruptcy specific provisions in the CARES Act for people who are currently in a Chapter 13 case. They can extend their 5-year period up to 7 years to make their payments more affordable. But to be eligible for that, their cases must have been confirmed prior to the CARES Act, which would have been March 27th of this year. Other notable provisions, the federal stimulus payments do not count as disposable income. This just helps ensure people can still qualify for Chapter 7 despite any stimulus payments they received. And there was some they extended the small business debtor eligibility requirements, which can help a lot of small businesses qualify for the special type of new type of bankruptcy they created, the small business debtor Chapter 11. Now we're going to get into retirement considerations, first starting with retirement withdrawals. The CARES Act provided for the temporary elimination of the 10% tax penalty on early withdrawals from certain type of accounts with a $100,000 limit per person. To be eligible for this program, you must have a valid COVID-19 reason for early access to the funds. These include being diagnosed with COVID-19, having a spouse or dependent who's been diagnosed, or experiencing a layoff, furlough, reduction in hours, inability to work, or lack of child care due to COVID-19. CPAs are warning that you will be required to prove that COVID-19 has affected you personally if you want to take advantage of these provisions. Even if you are eligible for this relief, that does not necessarily mean you will be able to access your money in your workplace retirement accounts. That's because the CARES Act does not require employers to follow these rules. So you should ask your plan sponsor first if they are participating. The CARES Act also suspends the mandatory 20% tax withholding requirement that you have to pay when you do an early distribution from a 401k or other workplace retirement plan. But just because you don't have to pay the withholding when you're withdrawing the funds does not mean that you won't owe the taxes for it. This can create a potential tax landmine down the road if you don't plan ahead. At the same time, the CARES Act does give you added flexibility to manage the resulting tax liability. You can choose to spread the taxes out over 3 years, or you can still pay it all in 2020 if you want. Under normal circumstances, owners of certain workplace retirement accounts are allowed to borrow up to $50,000 or 50% of their vested balance, whichever is less. The CARES Act bumps the legal loan limit up to 100% of the vested balance or $100,000, again, whichever is less. This option is available for any loans taken out from March 27th through September 23rd of this year. The CARES Act allows borrowers to forgo repayment during 2020 and starts the 5-year repayment clock in 2021, giving borrowers extra time to repay their loans. but the loan will, however, continue to accrue interest in 2020. If you lose your job at any time in 2020 after taking a loan from your 401k, you have, under the current rules, until October 15th of 2021 to repay the borrowed money into retirement account if you don't want it to be treated as a taxable distribution. The CARES Act did not provide any specific relief for extending or deferring payments. However, you should check with your plan providers, as some have added flexibility as what to do with those distributions if the employee voluntarily or involuntarily leaves. The CARES Act also suspended required minimum distributions, or RMDs, for 2020 without facing the normal 50% penalty you'd owe if you didn't withdraw the mandated minimum. If you've already taken out your 2020 RMD and the distribution was within the past 60 days, the CARES Act allows you to consider the distribution eligible for a rollover distribution and put it back into your account. However, if you took your RMD more than 60 days ago, there's currently no legislation that will allow you to roll it over. Or the reasons for not taking a distribution? So you can leave your money in the market if you want to take advantage of the anticipated recovery we hope is going to happen when the crisis has abated. And you also avoid having to pay taxes on the distribution. What are the reasons for taking the distribution? Because you need it. And there's no shame in that. Do what's best for you. But a good rule of thumb is to only take out as much as you need. So now we're going to get into the last part of our presentation, which is dealing with default. Some good practices for that are to first request any and all forms of relief available to avoid defaulting, including an interest rate reduction. I saw a statistic from 2018 that said only 25% of borrowers requested interest rate reduction, but over half of those that requested it received it. So never hurts to ask. You don't want to stick your head in the sand. You want to be aware of what is going on with your debts, who has your debts, what's the status of those. We'll kind of go into the timeline of what happens when you're in default, and which I'll kind of illustrate why it's very important not to just ignore this. Finally, you want to consult with a professional, either an accountant, financial planner, or attorney well before making any major financial decisions. In efforts to avoid default, about 3 million auto loans and 15 million credit card accounts are on some kind of program to let people skip or make partial payments. But looking ahead, people could run into trouble because the terms of these hardship programs can be all over the map. There are no federal guidelines like there are for mortgages. Some companies will follow the mortgage guidelines and simply move the payments to the end of the loan periods, but they don't have to. The best thing I can recommend is to read the fine print to make sure you fully understand what is happening with the payments that you are missing. Another way to try to avoid defaults by liquidating assets to cover whatever shortfall there may be in your budget. A good rule of thumb is to not liquidate any assets that are already protected from your creditors. So you don't want to liquidate these assets just to pay your creditors. This would, in Florida, this would include your home equity as that is protected, and retirement accounts as well. So if you do want to liquidate, you generally want to use assets that are not protected from your creditors. This would be money market accounts, CDs, antiques, expensive jewelry. If you have a second home, obviously that wouldn't be protected from creditors as well. So when expenses exceed your income or your asset reserves, a person needs to make some decision on what they're going to keep paying and what they're going to default on. There's no right or wrong path here because everyone's financial situation is different and unique. Generally speaking, though, you'll need to keep paying for your basic necessities. This includes your utilities, as you'll need to keep the power on and the water running. As for whether you should default on your credit cards versus home mortgage, it really depends on your situation. Most people, like their homes, they want to stay in them and protect any equity there might be in them. For those people, be important to stay current on the mortgage and maybe choose to default on the credit cards instead. Others may have a house that has no equity and that they don't have any long-term plans to stay in. Those people may choose to keep paying the credit cards while defaulting on the mortgage. With respect to medical bills, the main consideration here is whether the bill is from a provider who you want to continue seeing in the future. If it is, then you'd want to pay the bill because otherwise the provider could refuse future service for failure to pay. But if it is not a provider that you're going to keep seeing, then it's okay to default on that if you need to. When you do default, what happens is that the original creditor will attempt to collect the debt through phone calls and letters that may go on for a certain period of time, usually at least 90 days or so, until ultimately they will charge off the debt. And that typically means they're just selling it to a third-party debt collector who will also attempt to collect on the debt through calls and letters and make it pass around between multiple third-party debt collectors until ultimately ends up at a law firm's office, who will also try to collect on the debt through calls and letters initially until they ultimately will file a lawsuit. You do have the opportunity to defend the lawsuit or still reach some sort of settlement with the creditor even after a lawsuit's been filed. But if not, if you don't do anything, if you have your head in the sand not paying attention, the law firm will ultimately end up with a judgment against you through which they can garnish wages or garnish bank accounts or levy property. So that's another example of why we want to be aware of what's going on with our debts. When you do start getting creditor calls, please know that there are some protections available. Creditors may not cause your phone to ring repeatedly or continuously with intent to annoy, abuse, or harass. So if you pick up the phone and you tell the creditor that you do not have the ability to pay and ask them to stop calling, and yet they still keep calling you repeatedly, that can very well be considered harassment. You would want to keep records and notes of any such calls if you do believe you're experiencing harassment. They may not use obscene or profane language or use false or misleading representations. A common one, typically by scammers, will be that they are with some sort of authority, some state or local authority agency, and that you may be arrested or something like that for your debts, which is not something that ever happens. Attorneys generally can take on these cases at no cost to clients. The creditors are required to pay the attorney's fees in the event of a recovery. But unfortunately, attorneys, we can't sue the scammers, these illegitimate companies. They're usually the worst actors, but they're illegitimate. There's no way to really track them down or get them to pay. A common method for dealing with credit card debt is credit consolidation, but you should be wary of such programs and understand exactly how they operate, as there are two different forms of consolidation. First, there's the settlement consolidation. This is probably the most popular one, but unfortunately it can be the least effective for people or cause the most long-term damage to people, because under this type of program, creditors are not actually getting paid. Instead, you're just sending your monthly payment to this credit consolidation company who holds the money in a savings account or escrow account. And what they're doing is they're trying to save up enough money over time to ultimately settle out the debt. But this takes time. You have to accumulate around 40 to 60% of the balance in order to reach a viable settlement. So what generally ends up happening is that the creditors lose patience because they're not getting paid, and they may file a lawsuit before you're able to complete this program, which can then just force someone into filing a bankruptcy to make the debt go away. Another type of consolidation is the payment adjustment method. This is one where the creditors are getting paid. They just have arranged for the creditor to accept less than the monthly payment, than the minimum monthly payment. The main negative drawback of this type of program is that not all creditors may participate, And you may feel like a hamster on a wheel, not getting anywhere, because as you were paying such small amounts, the principal balance isn't really going down. So it's not really an effective method for eliminating debt, but it can serve as a form of temporary relief to help you avoid going into default. If you find yourself in a situation where you have defaulted but want to get back into the good graces with your creditors in one form or another, you can always attempt to settle the debt yourself. You don't need a consolidation company to do that for you. There's two different types of settlements that you can engage in directly with the creditor. You can establish a monthly payment settlement. You won't get any relief on the total amount. You'll still owe the same amount that you owe. You'll just pick up with the payments at an agreed amount in time. And then there's also lump sum settlements. Typically, you'll only be able to perform these with third-party debt collectors. The original creditors typically won't engage in these. But under this type of settlement, you can usually get the creditor to settle for around 40 to 60% of the debt owed, but you have to come up with that money quickly, usually within 30 to 90 days. And at the end of the process, at the end of the year, after you've done this type of settlement, you'll receive a 1099 tax form and for the forgiven amount, which will be treated as income by the IRS. So you may end up with a tax bill after doing this type of settlement. If settlement, consolidation, none of those other options are available to you, bankruptcy is an option. Some people don't think it is due to some common misconceptions about bankruptcy. First, some people will say the new-ish bankruptcy rules from 2005 make it too hard to file for bankruptcy. That's not true. The vast majority of people can still qualify for the simple Chapter 7 bankruptcy, even under the new rules, and so it largely does not affect them. The new rules really just establish a uniform way for determining disposable income and making people pay a certain amount to the creditors in Chapter 13 cases. Another thing I hear often is that I can't afford to hire a lawyer, whereas lawyers typically will have very flexible payment plans. Especially as of late, lawyers have come up with a lot of creative ways to make it easier for their clients to pay them over an extended period of time. So, ask around, get some quotes, see what their terms are, and usually it will be a very small fraction of the debt that you owe. Another misconception is that you may lose all of your assets. This is definitely not true. You're entitled to certain protections on your assets in bankruptcy. These are called exemptions. To the extent that anyone's assets exceed the limits of their protections, it still doesn't mean that they have to lose their assets. They can always pay the difference between the value of the assets and the limits of their protections in order to retain all of their assets. So it's never ever have to lose your assets, just no matter how much is it going to cost in order to retain them. And there's different time frames that you can be given to make those payments. People also think they won't have any credit for a long time after a bankruptcy. That's also not true. Right after your discharge, you immediately become eligible for credit card offers and car loan offers, auto loan offers. Obviously, you're not going to get the best rates starting off, so you don't want to jump into a big loan with a bad interest rate immediately after your bankruptcy discharge. But you can start building up your credit with credit cards, just paying them down each month to start building up your credit and get better rates. You do become eligible for mortgages 2 years after your bankruptcy discharge. And just to give an idea of how quick bankruptcy happens, in a Chapter 7, your discharge happens 3 to 4 months after the case is filed. So you can really kind of get right back into having credit if you need it right away. Last misconception, I'm a bad person because I filed a bankruptcy. Obviously not true. Listen, there's no shame in having to file a bankruptcy. It's a financial decision, pure and simple. And as we've all seen, there are circumstances way beyond our control that can devastate a person's finances and necessitate the filing of a bankruptcy. Being a caregiver in itself can be that devastating. And for those of you who are caregiving in the middle of a pandemic, I can't even imagine how hard that is. All I can say is that my heart goes out to each and every one of you, and I'm more than happy to help you in any way that I can. To that end, provide some online resources here. Firstonebenefits.gov. This site can connect you to a broad range of government programs in your state. You can search the site to find different programs by state, by agency, or by categories, such as healthcare or disaster relief. The 211 program by the United Way helps connect people to aid programs in their state. You can use it to find food and nutrition programs such as food banks, shelter, housing aid, and utility assistance, and other programs. If you do need help from an attorney, you can search for a legitimate consumer bankruptcy attorney at NACPA.org. They keep a list of all attorneys in their network to make sure you're not getting a fly-by-night attorney who doesn't really know what they're doing. And then finally, we have our host, AARP, of course. AARP.org caregiving is hosted to many resources for caregivers. So that completes our presentation. I'm going to put up my contact information here. Please do not hesitate to contact me should you have any questions or concerns after our presentation today. I will be here and available to you. But for now, we are going to open things up to any questions that any of you may have. So we will do that now at this time. All right.
Hello, so much, Ryan. Hi.
You're very welcome.
Thank you. That was just fabulous. And I can't tell you how much I appreciate your wise, calm wisdom. I'm sure there are a lot of caregivers and families who are just trying to figure out, what do I do? How do I start with this? So one thing I wanted to clarify, you indicated in your presentation that unemployment benefits were an extra $600 a week, but the PowerPoint said month. So I just want to clarify that. If it's an extra $600 per week in benefits or per month?
Yes, that should be per week. I'm sorry.
Oh, okay.
Or let me, actually, I'm just looking at my notes here.
Okay. So that's even better news for folks that may be listening and watching. You also gave a lot of information for homeowners about a variety of different programs that they might be eligible for, whether it's a federally backed mortgage or a private mortgage. What if folks just are unsure, really don't know what to do first? What would you suggest a homeowner's first course of action might be?
Well, you definitely just reach out to your lender. Find out what options are available to you. If you're not sure if it's federally backed or not, you can just ask the servicer directly to find out that information. That would be a good way to find it. So yes, that they're usually more than willing to talk to you, provide that type of information. So don't be scared to just pick up the phone and ask. Yeah.
Okay. And I think it's really good advice that you gave everybody, that if they have financial concerns, whether it's their auto loans, credit cards, mortgage, to pick up the phone and call their lender, because you gave that statistic that only 25% of people do so.
Right.
So maybe the first thing to do is call your creditor and ask them what to do.
Absolutely. Now more than ever, creditors are offering all different types of programs. Again, just make sure that you're reading the fine print and you understand what's happening with those missed payments. Okay.
And lastly, one thing about healthcare that you mentioned, which was also very important, if you have debts related to a healthcare provider, see which one you may want to pay first, specifically those that you want to still see or see in the future. You can correct me if I'm wrong, but isn't medical debt a very large contributor to overall financial debt and possibly bankruptcies?
Oh yes, it's the number one reason why people need to file for bankruptcy is medical debt. So yes, that can be a devastating one for sure.
Okay. So although all of us still need to utilize healthcare, it can be expensive. So make sure you continue to have those conversations with your providers. Ryan, I just can't thank you enough. For those of you who don't know Ryan and his wife, Amanda, they are both rock stars in the legal world on behalf of caregivers. So on behalf of AARP and all the caregivers out there, I want to thank you so much for your time and your expertise today. For those of you who registered for this webinar in advance, I will be sending out the PowerPoint slides that Ryan showed today, as well as his contact information. If you joined us live on Facebook or YouTube, you can send us a private message with your contact information, your email address, and we'll be sure to get those out to you as well. So Ryan, thank you again for being with us. I wish you a lovely afternoon.
You too, Leslie. Thank you so much for having me. Have a great day.
Thank you, Ryan. Take care. Bye-bye.
Take care. Bye.